took the offer and the case was dismissed. Today in this video, I am going to be talking about dismissal and why you should take it when it is offered, depending on your situation, okay? Case by case basis. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. We have TikTok, Instagram, Facebook page, Facebook group. Let's get right into the topic. Dismissal. Why should you take it? Well, you take it when your case is weak. You take it when you have other ways of working, like you can work even if you have no work permit, especially for business owner. They do work. A lot of them I know work without work permit because they own their own business. Yes, you can take a dismissal when it's offer. You can take dismissal when your case has no merit. You can take a dismissal when you miss the deadlines. So this is the case where this client actually applied for asylum 10 years later. Remember, asylum must be applied within 1 year deadline. If you miss the deadline, you have to have either extraordinary circumstances or change in circumstances that materially affected your ability to apply earlier. When you go with extraordinary circumstances, well, it has to be related, okay? It has to be really in direct connection to you failing to apply earlier. And if you go with change of circumstances, you have to show that it was so material that it affected your ability to apply for asylum earlier. And once the change of circumstances came about, you apply later on within a reasonable time. That's asylum, okay? And then you still have to prove a fear of present, past, or future persecution. We know all that. So this is where the case was weak because missed the deadline and we had no element as far as change of circumstances. We had no element as far as extraordinary circumstances. Everything we had was our own words. We had no tangible proof to prove it. If you say somebody died, well, you have to show the death certificate. If you say somebody was sick, where's the medical report? If you say, well, change of country conditions, well, you need to show it with a country condition report. So you have to have evidence to support your claim. So in this case, we had weak evidence, really weak, okay? And then we wanted to claim cancellation of removal. Still, it was weak because remember, cancellation of removal, you have to prove extreme and unusual hardship to your qualifying relative, okay? Unusual means that it's rare. It doesn't happen to anybody. If you're claiming that because you're divorced, your kids will suffer, well, if we go with the statistics, a lot of kids here live with divorced parents, okay? In two households. 1 week they'll spend here, 1 week they spend there. It's not uncommon. If you want to claim that somebody was sick, well, what type of sickness? Is it just headaches? Anybody can get headaches, okay? So it has to be extreme and unusual. So we had to find facts. If you're claiming that you have some type of mental illness, then we need to show the mental professional doctor report. If you don't have it, your words alone is not sufficient. So we had weak evidence. We really had weak evidence. We were just going to go because we had to appear in court, but we had weak evidence. So when DHS went through the record, remember that the the parties are encouraged to talk about stipulation before the hearing. So when DHS went through the record, they found out that really we had nothing, and they were going to oppose everything, and they offered dismissal as a solution. And I had talked to my client to look at the pro and con and decide. Then we came up with that resolution together. Okay, without any reservation, we took that dismissal head on. We took it because we know that now our client can go back to USCIS. Once he becomes eligible to adjust status, he can adjust status without any hurdle. Okay, so that's why we took it. Not to mention, the client has his own business, so the fact that he's no longer going to have a work permit doesn't matter, because he has been working even prior to getting that work permit without a work permit, because he owns his own business. So you have to look at the circumstances around you, okay? Whether you have an alternative way to adjust status, child who's going to turn 21 anytime soon, you can work without a work permit, you can get married to a U.S. citizen. Those are the things you look at. And whether your case is really weak and you don't want to just move forward, especially if the claim is baseless without merit, what you don't want is for DHS to say that this asylum claim is frivolous, and that will bar you from anything. So you really have to assess, think about it, sleep on it, then come with your final decision on a dismissal order, especially when you have an alternative way. Okay? That's why we took that dismissal. Moral of the story is this: if you want to take a dismissal, remember that the dismissal does not offer you anything else. When they dismiss the case, whatever work permit, once it expires, that's it. You cannot renew it because you have no claim under which your work permit should be granted. So you stay with nothing. The only thing that's good about it is that you don't have the order of removal under your belt. So if something becomes available, you go straight to USCIS and adjust status. So those are the things you look for when you try to decide for a dismissal, whether or not to take it, okay? So that's why we took it. It was the best possible outcome for our client. That's why we took it. Remember, the best possible outcome for our client. And if you keep pushing, you go there, you get denied, you go to BIA, get denied, you go to federal court, get denied. Do you know how much money you will waste in attorney's fees, time, energy, emotional distress, mental distress, contemplating suicide? Well, you don't want that. If you have alternatives, you don't want that. If they offer it, you take it. And if you want to decide whether you should take it or not, you can consult with qualifying attorney. If you don't have one, you can call me, 202-751-2180, or you can schedule a consultation on your own time by clicking the link in the description box below. Other reason why you wanna take it is because you don't want to put yourself in a position where DHS offers you a dismissal and then later on you end up losing in court and going back to them to reopen the case and terminate removal proceedings. Trust me, my friend, you will wait for a very long time, because at that point the case is no longer a priority. They already offer you that, you didn't want to. So it's not their priority. It's just going to be there until they get to it, when they want to get to it. Your life, your choice, make a better one. If you want people to help you make a choice, you can always consult, but because it's your life, it's about your life, it's about your family, make a choice and make a better one. We took it, and we are happy with our decision, and we wanted to share the reasoning as to why we took it. Until next time, bye-bye.